We're going on the record on cause number DC 204968, Jones v. Johnson. Counsel, make your appearances.
Rob Lohr for the plaintiff, Joe Jones.
Don Stillwell for the defendant, Allstate.
And we're here on a motion to compel, correct?
Well, we also should have our motion to sever and abate.
Well, we've got 3 hearings that are currently set for this morning. We've got a motion to strike counter-aff of Dr. Leak, a motion to strike counter-aff of Clifford, and then a motion to compel the corporate representative deposition.
But we also should have the motion to sever and abate, which we filed more than 2 months ago. And
you're correct. Those are all set.
Okay.
Which do you want to handle first?
I don't have a notice of hearing on a sever and abate hearing, but
you filed a response. The plaintiff filed a response a week ago.
Mr. Stillwell sent out. I don't know if it was sent to you as well, but he did send out a notice on the motion to sever and abate on January 6th. He sent it out.
He sent a letter that says we are requesting a hearing.
Oh, okay.
I mean, they're all part and parcel. If he filed a response before that on January 5th, we had this set before we filed the motion back in, I think, November. I mean, they're part and parcel of the same. The motion to compel, motion to sever and abate doesn't relate to the motions to strike, I guess. So if he doesn't want to hear the motion to sever and abate, then I would ask that we hold off on the motion to compel. We can go forward on the motions to strike.
Well, that's certainly unreasonable to us, Your Honor. We noticed the corporate representative deposition unilaterally because we couldn't get agreed date from Stillwell's office or a response at all. We had a hearing set on November 16th, Your Honor. This was 3 days prior to the date we had noticed the corporate representative deposition for. So we were going to have that quash hearing 3 days before the deposition. And what we anticipated happening is you denying the quash, because at that time it would be really hard not to deny the quash, and then we could go ahead with that hearing with that deposition as noticed on November 18th. However, Mr. Stillwell contacted me, asked me for a favor because he had lost somebody at his office. I think somebody had left for one reason or the other. He had some conflicts, and so he asked me for a favor to move that November 16th hearing on their quash. You give an inch, they take a mile. I grant that favor, and then here we are. The next day, they file this motion to sever, and now we've got to compel on the same depot, and now he's trying to have this, motion heard before our compel or at the same time of our compel. So, I'm getting punished for my favor that I did, and I should have learned a long time ago not to do those favors, but I guess I'm still a little naive, Your Honor. But right now, we certainly would object to a motion being heard that has not been set for hearing. We do have a motion to compel this corporate representative deposition, regardless of the sever and abate motion being heard. I anticipate this deposition going forward regardless, so it's more of a form issue. But they've had plenty of time to have this hearing set, Your Honor, so.
Well, we asked for it, and I've given many favors to Mr. Lohr. We're here to have it. They're necessarily part and parcel of the motion to compel. If I would ask, they're clearly ready. They filed a response, but if they don't want to go forward with the motion to sever and abate at the same time, whether it be immediately before or immediately after or contemporaneous with their motion to compel, then I would ask for a continuance of the motion to compel, and let's go forward with the motion to strike.
When was the motion to compel? When was that hearing set?
In November 18th.
It was set. That was the date that this hearing was set, was on November 18th?
Yes, Your Honor.
Yeah, Mr. Stillwell, why did you wait until January 6th to set your hearing at the same time?
We actually asked before. We weren't getting anywhere with the court. Said that they were full, so we sent our letter you say, look, we requested it before January 6th. We filed our motion in November. I don't see any reason why we couldn't have them together. We had orally asked that it be set. We weren't getting anywhere, so we papered the file. I think we've done what we can to get our hearing on our motion.
I mean, Mr. Lohr, you did file a response. Are you not prepared to argue this today? Is that the issue, or did you? I mean, what?
I'm prepared to argue. I'm frustrated that I do a favor. We have a quash hearing on November 16th, and there is no way you can't deny their quash and we go forward with the deposition on November 18th that we're trying to compel. So that's why I'm frustrated. I already had this deposition in the bag 2 months ago if I don't do a favor, and now they're trying to take advantage of that favor. That's why I'm frustrated. That's why I'm objecting to the form issue here.
It doesn't stop a deposition. This doesn't stop a deposition. It's the same thing. The deposition should be narrowly tailored, as we can discuss. But I've done favors for Mr. Lohr before.
Let's just do that. We're kind of going around in circles. I'm going to go ahead and hear. I'm going to hear the two motions to strike first. I'm going to hear the motion to compel next. If I have time to hear the other motion, I'll hear it. If not, I'll reset it. But we have a limited amount of time, and I can't keep going around and around on the same issue. So, Mr. Lohr, why don't you begin?
Yes, Your Honor. We've moved to strike the counter affidavit of Roger Clifford. Mr. Clifford's produced thousands of counter affidavits. He's the same medical providers in the area, hundreds of medical providers that he controverts. They all charge essentially the same, and they're all wrong. Mr. Clifford's right, and he knows who should be charged what and what services they should receive, as opposed to every other medical provider in the DFW Metroplex. And the counter affidavit that Mr. Clifford provides, he says none of the services that Ms. Jones, my client, received were reasonable. But the problem with his counter affidavits is that he provides a causation and then a lack of documentation counter affidavit. He puts in his counter affidavit. I'm on page 3 of my motion to strike, Your Honor, and we quote these counter affs. It says, there was no indication in the chiropractic treatment records that the chiropractor understood the mechanism of how the wreck happened or the mechanism of injury, which is, some nice insight to us as to what Dr. Clifford's trying to do. And he's trying to say that the treatment, that the injuries were not caused. So he goes on to say that specifically. But he's saying the treatment that Ms. Jones received wasn't caused by this wreck. And that's obviously something inappropriate for a counter affidavit. Was the treatment necessary for the injuries that Ms. Jones came to the chiropractor for? Not were they caused by this wreck. And then he just makes a bunch of conclusory statements about that this chiropractor that Ms. Jones went to, the treating chiropractor, it was inappropriate for that chiropractor to treat a patient for the pain that they were in without asking for the details of the wreck. Very conclusory, unsupported. Again, more so on this same issue, Dr. Clifford cites articles and things about pre-existing injuries, saying that the injuries that Ms. Jones was being treated for were pre-existing. Again, a causation issue, saying that the treatment that Ms. Jones received was not related to this wreck. Again, inappropriate for counter affidavits. There was some services, Your Honor, Dr. Clifford says that weren't necessary because there was a cheaper alternative. And I'm on page 5 of our response, specific to hot cold packs, saying that, well, Ms. Jones should have done these hot cold packs at home. So it wasn't necessary. And that's obviously counterintuitive. He's saying she should have had these hot cold packs. She should have just done them herself. So he is saying that treatment was necessary. that there was a cheaper alternative for doing it by herself at home, and therefore it was unnecessary. So again, this, he's contradicting himself, and then the fact that there is a cheaper alternative does not wholly make a treatment unnecessary. I believe we just have in our response just several other examples similar to that. We do quote our borough opinion on page 6 of our response, that there must be this reason basis, and when the bases are contradictory, we argue that that's not reason, Your Honor. Dr. Clifford talks about future medical costs that Ms. Jones may or may not need, again, inappropriate for a counter affidavit. Then we get into, on page 7 of our response, Your Honor, Dr. Clifford says, okay, well, if some of this treatment was necessary, the charges were unreasonable. And the support for Dr. Clifford's opinions about the charges is what is payments, what a patient would pay. A self-pay chiropractic patients typically pay. What Dr. Clifford himself charges are his reasoning for, or his basis for what a reasonable charge would be.
So I'm looking at the report right now. I see where I do have a lot of concerns about Dr. Clifford's report. I'll be honest with that. This is, I think really what was done here, and it's not a bad strategy by Mr. Stillwell, is that he hopes that we're going to have a dueling affidavits, and they threw a bunch of stuff in on causation here, and which is, I don't blame him. It's a good strategy, but it's not appropriate for counter affidavit. But I'm trying to find. I see on page. I'm looking. If can you on the share screen? It's not numbered, unfortunately. I guess it's paragraph 21. He compares the fees to health insurance plans, Medicare, Medicaid, and workers' comp. I don't allow that. That's apples and oranges. But then he goes, the charges I included that would have been reasonable in this case are higher than the ones I personally charge. Does he ever go in and talk about what the reasonable charges are based on his review of the charges in the Metroplex or anything like that?
He provides, for example, it's in Exhibit A, page 6 and 7 of our response. He refers to his own charges, and then I guess on page 7 he provides his reasonable charges, which are, as he states, what he considers a reasonable charge is in excess of what he actually charges. But he does not necessarily explain how he arrives at his what the top end of a reasonable charge was. He kind of just says,
what paragraph does he go through reasonable charges on?
22.
22 or okay. All right. Mr. Stillwell, response?
Number one, he clearly compares the charges at issue with his own charges. That is certainly reasonable for the doctor to do. I do disagree that the other charges and the payments are not reasonable. The Cypress Creek case clearly discusses that what payments are for different payment sources could be relevant as far as what's reasonable and necessary. As far as the causation issues, I mean, if we can certainly strike those from the counter affidavit, but I think the inclusion of causation statements does not make a counter affidavit effective, nor an 18001 to say that. Having said that, 1801 does not establish causation. And, I think Dr. Clifford gives them reasonable notice. All the law requires is some reasonable notice. It doesn't require anywhere near what the plaintiff attorney tries to convince the court that it requires. I would ask the motion be denied.
This is still, I can barely hear you, but okay.
Yeah, I'm basically just highlighting that Clifford talks about his own charges. He gives it as a comparison. He does give other examples of why he believes the charges are unreasonable. Regarding the dueling affidavit issue, if you want to strike the causation sentences, we can do that. We offer dueling affidavits in every case because plaintiff attorneys say that it's a cost savings fund. Either they're retained experts that they use on a routine basis. I don't believe they charge, but if dueling affidavits certainly eliminates any cost savings issue.
Mr. Lohr, would there be any situation where you would agree to dueling affidavits? I know your firm usually doesn't do that.
No.
No, okay. All right. Well, it's all right.
Well, I mean, the motion to strike should be denied, and we, it shouldn't always be their way or the highway. I mean, it's because they don't want to do dueling affidavits. They want to do them when they're denied, when the motions are denied, which to me is not consistent.
Well, that's not true. But when your support for your basis that this treatment is unnecessary is founded upon your opinion that the wreck didn't cause the injuries, then it's more than just striking out those causation portions. The counter affidavit is fatally.
So, Mr. Lohr, the only portion of this that I'm considering is really paragraph 22, which goes through, I guess what he says the reasonable charges are.
Well, like we've talked about, he's reasonable charge is based on what is paid by different people, Medicare, Medicaid, comp, and what he says self-pay chiropractic treatment is. And we're talking about what's a reasonable charge, not what is a reasonable payment. So he's not, it's apples and oranges in a free market, pay
No, it's not. No, it's not. I mean, if in a free market, if you're talking about all these different places, that's what they charge, such as himself, how is that objection?
Okay, so I'm looking at paragraph 21, and it says the charges I included that would have been reasonable in this case are higher than the ones I personally charge. I'm a preferred provider for blah, blah, blah. And then he says, I have a detailed knowledge of the allowable charges under these plans, and I'm aware of what self-pay chiropractic patients typically pay. In my work providing expert peer reviews, I reviewed thousands of charges by chiropractors in the Dallas and Fort Worth region and other regions around Texas, and I'm aware of what large numbers of my colleagues charge. I teach at, see, blah, blah, blah. It says the charges included as reasonable in this case would be reasonable whether the patient is self-paying their chiropractic services or using insurance. On the contrary, the amounts charged by the chiropractor provided in this case were not reasonable whether the patient self-paid for their services or used insurance. I mean, if there's any ever that's about as broad as you can get. I mean, I would say that
where does this range come from? He's reviewed it and then he's put some top end number on it. He's not comparing who these treaters are. There's obviously a difference between different providers, and different folks do a better job. Is that considered?
The law doesn't require as much as he's saying it does. If the law requires it, point to me where in the statute it requires that. It doesn't. We're basically trying to change the law by creative argument. nowhere in the statute that says what he says.
I mean, my suggestion would be that we do dueling affidavits just as to the chiropractor bills. I'm going to strike them as to the MRIs and all that other stuff. But as the chiropractor bills, and just include in a few sentences besides the intro sentences about his background out of 21 and 22, where he talks about what the reasonable fees are for self-pay. I would suggest that. If that's not agreeable, then I'm going to.
We can do that. We can adjust it as you see appropriate.
Mr. Laura?
I mean, it's not, it doesn't get in. Either I have to prove up my bills or I don't. So I understand the court's position if they're saying this is sufficient as to the billing amounts, and this is a sufficient support for that, and that's the court's ruling. And the law is the law. We're not writing the law today. We're doing our best to work with it. And the law says either it's good or it's not. Either I have to prove up my bill through some other means, or my affidavit gets in.
You're absolutely right, but I've also tried dozens, if not hundreds of cases with dueling affidavits. It's something we do all the time in Dallas. So if you don't want to do dueling affidavits, I'll deny the motion to strike, or I'll deny the motion to strike as to Clifford versus the chiropractor. I will strike everyone, Clifford versus everyone else. And if you'd rather just call your chiropractor live, that's okay. But I do think this is sufficient as to reasonableness. The rest of it I would cross out, because I think there's a lot of causation stuff in here. And comparing the bills to health insurance or workers' comp, I would strike that too.
Right, and that's part of his support for what he believes a reasonable charge is, which we all agree it's not appropriate. So
I agree with that, but that's not the only basis. He also goes into reviewing other chiropractors. I mean, I'm pretty strict on these. I guess I'm not. I used to think I was the strictest on these, but I've heard there's some other judges who are stricter now, who strike every single counter affidavit, and I just don't think that's in accordance with the law. But I strike a large number of them. It's just on this one, I think it gets through on that one issue. So it's up to you, Mr. Lohr. What do you prefer?
I guess I understand the court's ruling. I believe that would you like us to present an order that tries to mirror what you're telling us?
Well, which do you prefer? Do you want to do dueling affidavits, or do you want to do?
I'm gonna call my chiropractor regardless of the how this hearing goes. So this just helps us in other parts of litigation when these counter affidavits are not outstanding. So it's either, like I said, I'm going to call them no matter what. I appreciate it.
Then I don't even see why we would even have the hearing.
You know why, John? You want me to tell you why on the record?
You bet. Go ahead.
Because we can't settle cases with Allstate with outstanding counterasks.
Well, that's ridiculous.
No, it's true.
That's ridiculous.
And the offer automatically shoots up once they get struck, and you know that.
That is ridiculous. There's case law that clearly says, with or without a counter affidavit, the defense lawyer can argue reasonableness and necessity.
I understand that, but at mediation, all of a sudden the offer goes up when the counterasks are struck. That's why we do this. Y'all make us.
Well, so it's a waste of time.
I disagree.
Right, you have another one that we need to look at?
Yes, Your Honor. We moved to strike the counteraff of Dr. Dustin Leak. This was an interesting one. When we first got it, it kind of opened my eyes a little bit. It was refreshing to see, I'll admit. Dr. Leak had a real problem with a very specific part of the treatment that was provided to Miss Jones. So Miss Jones had some interventional pain injections, and the orthopedic decided to use a pretty deep sedation method using propofol. This is not something you typically see in these sedation methods. Typically, it's a less significant sedation medicine. But in this case, for the one reason or the other, the treating physicians used this propofol sedation. And Dr. Leak has provided his opinion that that was not necessary, should not have been done. But the support that Dr. Leak provides to support his position is different areas saying this is not what you would typically do, which we agree with. It's not what's typically used, but there's nothing that says you can't use it or to not use it. It says that it's not typically done. Most of the time, it's not required. But what Dr. Lee doesn't do in him saying this propofol wasn't necessary is say that either you can't ever use it. He never says that. Or why it was that Miss Jones wasn't one of these patients that is one of those outliers, why she's not the atypical patient who could have this propofol as far as for her anesthesia. So we agree with Dr. Leak that this is an unusual and atypical medicine to use in the sedation process. But what Dr. Leak doesn't tell us is why Miss Jones isn't the atypical patient, where the treating doctor obviously found that she was, due to her medical history and issues and the procedure that she was undergoing, that she needed this more significant sedation. And what I cannot tell from Dr. Leak is why it is that Miss Jones doesn't fall into that atypical patient, or what she would have needed to have, what he would have needed to have seen for her to fall into this atypical patient profile. So I have no idea why he says that she can't have this propofol, other than that it's an atypical thing to use. So that's the necessity portion of his affidavit to the most, for what we could tell for the most part, Your Honor. So we'd obviously argue that he hasn't provided us a reasonable basis. As far as the charges, what is typically reimbursed is what he says. He says that the charges from Epic Pain, an injury, their charges are in excess of what's typically reimbursed for medical services by Medicare, Medicaid, private health insurance. So again, that's not what we got here. We don't have a Medicare, Medicaid, or private insurance case, and therefore his basis and reasons for these charges being in excess, we ask that. And in addition to the James Davis Medical Fee Dictionary, which didn't provide, that would not be a reasonable basis to rely on when determining what's a reasonable charge or not. That's all we had on that, Your Honor.
Response?
Our doctor spells out the reasons for his opinion, which are consistent with 1801. The fact the plaintiff attorney is trying to go way beyond what the law requires. Regarding whether plaintiff wanted to use their health insurance or not, that doesn't eliminate the fact that the doctor's opinions can be based upon what different payers pay plus what their own charges are. In this case, we have a $906 ER bill after paid or incurred. Epic Pain has exorbitantly high bills on a regular basis, and our doctor says why he thinks the charges are not reasonable and necessary. I believe the motion to strike should be denied. Similar, it's like in any case, in every case, we offer standing offer to do dueling affidavits on every case. I ask that the motion be denied. The plaintiff attorney.
Yeah, I don't see this one as anywhere near as close a call. I'm going to go ahead and strike this affidavit. All right. Anything? Oh, we're kind of out of time at this point. We have the motion to take the deposition. Is that right? Or let me just ask for the next hearing that's up, the 9:45 hearing. Do y'all still need a hearing?
Yes, Your Honor.
Okay. Let's try to get through with this motion to compel real quick. Was there an issue as to this, I guess, the scope of the?
There is.
Okay. What's the issue?
Well, I mean, I don't want to go into any claims handling. I don't want to go into any basis of the offer. The adjuster is not going to the adjuster is going to be just like plaintiffs often do. We're going to defer to the jury. I don't really see any basis to have the deposition at this point. But if they're going to have the deposition, it should be limited to coverage, offsets, things that the adjuster would have personal knowledge of. I don't see why, if the adjuster clearly didn't witness the accident. The adjuster is not a medical expert. Can you name one time where this court has ever permitted an adjuster to get out there and express their opinion as to how they think the accident happened, or what they think about the plaintiff's medical providers, or epic pain, that it's always letter of protection type care, and how they think it compares with health insurance? The court would never permit that. The pushing for depositions is merely, like what Mr. Lohr said on the record moments ago, to try to extort settlements out of adjusters. If the adjuster has some independent knowledge that can't be gained anywhere else, then okay. But in this case, we're willing to stipulate that there's coverage. We're willing to say these are the limits. If they show legal entitlement to recover, which hasn't been shown yet, then Allstate's on the hook for, subject to the terms and conditions of the policy and the offsets and so forth. But my concern is that, and I think the Supreme Court's concern, is that plaintiff attorneys have used this as a settlement tool as opposed to a fact, because there's nothing to find. I would venture to say, Judge, you and I have known each other a long time now. I've never tried a first-party case where an adjuster testified. I'm here to stipulate the adjuster's not going to get up there and testify to A, B, or C. They're not going to testify to anything. And why is that important? Because that's the only reason to take someone's deposition, is if they're going to get up there and make an opinion. Allstate is entitled to rely upon me having core work product, ideas as how I'm going to defend a case, just like the plaintiff is entitled to rely upon Mr. Lohr or any other counsel from his firm to try their case. I really just see these adjuster depositions as merely a tool to extort settlements and not to find facts. Because if the adjuster is not going to testify and they're not allowed to testify, I mean, the adjuster can't get up there and say their opinions about liability. No court's going to let that happen. No court's going to let anybody get up there and testify that wasn't involved in an accident or didn't witness an accident, are they? If so,
Okay, so let me hear from Mr. Lohr.
Well, generally we get a Rule 11 and get some agreements on via that method and to avoid some depositions, Your Honor. So they are, we do have to have some discovery with Allstate to, get the policy proved up and those type of fun stuff. So, that's pretty silly argument as some sort of extortion method. But in this case, Your Honor, this is a little bit unique because we do have some claims that may be severed eventually, but they will go on as they are ripe and they would not be found moot by any type of judgment in the underlying case. Because prior to this lawsuit, we sent some fraud notices to Allstate, specifically in the most, I think, pertinent claim is that Ms. Jones would have never paid the additional premium that she paid to Allstate for UIM benefits if Allstate had not fraudulently failed to disclose that they would require lengthy litigation for her ever to recover these benefits. She was induced into this consumer transaction by Allstate's failure to disclose this to her, and she didn't find out about it until shortly before this lawsuit, and she would have never paid those additional premiums if Allstate would have done their duty and disclosed that to her. So she has this claim for those additional UIM benefits that she's paid to Allstate. Allstate has not responded to our discovery request for an itemization and accounting of these additional UIM premiums that Ms. Jones has paid. And Ms. Jones would not have signed up for this UIM coverage if Allstate would have been clear and non-fraudulent in the inducement of that contract. So we've got an additional DTPA claim. We've sent them proper notice, 60 days prior notice, and we filed a lawsuit against them. And part of our claims in this case, in this cause number, are DTPA claims against Allstate for this fraud. We've got several other fraud claims.
And those have to be severed and abated, and we charge a whopping $73.50.
I'll let you pontificate about the plaintiff's bar for 5 minutes. Just give me a minute. And so we have some live DTPA claims that are in here that we just have a general denial to, and this is a discovery deposition that we're asking for. And it sounds to me like for Mr. Stillwell, it's not going to be very long. This hearing is going to be longer than this deposition, because it sounds to me like Allstate's just going to say we rely on the jury to make these decisions. So I don't know why we're going to spend so much time motion drafting and all these things to protect the corporate representative from a 25-minute depo where they just say we rely on the jury to make these
Don't know
decisions.
how long you'll ask the same question. I mean, they charge 70. This is a properly to be severed and abated out anything about DTPA or claims handling, and you know it, and the court knows
I don't think it would be abated, John. I don't know why it would be abated. I don't think it would be abated, so I don't know that. No. So
why would the extra contractual claims not be abated?
This cause number or new cause number, it's still going to happen. We've been asking for it. We should
What
have
could happen? Can happen at the appropriate time, which is post judgment, as far as the extra contractual claims. As far as, I mean, coverage, we've stipulated that. We've produced the policy. We've produced how much it costs for the UIM coverage.
So let me just say this. I'm going to allow the deposition to go forward. I do think the scope is a little broad in what's requested. Why don't we do this? You guys, why don't you guys discuss what exactly you need? I do agree with Mr. Stillwell that, you can't really ask him about, what is their, evaluation of the medicals and all that kind of stuff. But there is a lot of stuff in there that you can ask about. There is, I actually had an intern a couple summers ago who did a research project about this exact topic, about taking depositions of adjusters or corporate reps of insurance companies and UIM. There's clearly some case law out there that allows it, but it needs to be limited in scope. And so why don't you guys try to work that out, the exact scope? If you really need to have another hearing on this, we can reconvene. But I have faith that you guys have worked together before and you guys can work that out. So
we'll do the best. We'll do the best we can. And Judge, I think this is going to be narrowed greatly by the Supreme Court. It's got a case coming up in the next month or so. They may have already heard it. I've been trying to find out. This USAA case has been on the docket. I'm not exactly sure if it's been heard or not.
Well, if there's new case law I need to know about, the memo was done the summer before last, so
I don't think I'm certain the new opinion has not come down. I'm not sure if it's been argued yet. B. Smith is handling the case that's on appeal to the Supreme Court. They granted, because of, like you said, there is some case authority that goes both ways, but they seem to be unanimous about how narrow the definition is.
Well, obviously, if the Supreme Court rules on this issue and gives us some guidance, we'll follow that guidance.
Absolutely. Thank you, Judge. Well, Mr. Lord and I will communicate, and then we'll set at a later time our motion to sever and abate.
Okay. And then if you guys can't agree on the form of the order, did you submit orders? I guess, give me just an omnibus order that covers all three of these motions. If you can't agree on them, then just submit separate orders.
Well, it sounds like we have, the court is allowing the deposition. We just need to talk about the scope.
Right.
And that they can't ask about evaluations and go through the medical and so forth.
Yeah, so try to get me an order that covers all three of these. All right, guys, thank you. You guys have a good day.
Thank you, Your Honor.
Okay, I think the next hearing we have is anyone here on the Sloan v. Huff case or Hoff case?
usually should on the
Anyone here on that? Sloan v.
Mike
Hoff.
appears on behalf of defendant Huff.
Okay.
Forrest Mays on behalf of the plaintiff, Your Honor.
Okay. And we're hearing a motion to strike.
Yes, Your Honor.
And I didn't see a response was filed to that. Was there a response filed to that?
No, Your Honor.
Okay. Let's go ahead and proceed then.
Thank you, Judge. So our motion to the court is in relation to Dr. Ozan. He has submitted 2 counter affidavits. I believe that they're essentially the same, and they attack, the necessity of the epic pain and orthopedics treatment. I don't believe any part of Mr. or Dr. Ozan's report or affidavit pertain to reasonableness of charges, but as the court is well aware, these counter affidavits cannot controvert the causation element of treatment, and I believe that Dr. Ozan's report, at least in part, attempts to attack the causation element of our cause of action through a counter affidavit, and that's inappropriate. Specifically, Dr. Ozan, states that he believes these are soft tissue related injuries, and that as such, they would have resolved within 4 to 6 weeks of injury. He then goes on to state that once my client sees epic pain and orthopedics in what he calls a quote a gap in treatment of 4 months, unquote, and then essentially identifies the physical exam findings, the reported symptoms from my client. He then goes on to state that any treatment that epic pain and orthopedics provided was unnecessary because it could not have been related to sprain and strain type injuries from the crash. Now, that assumes that Dr. Ozan essentially overlooks the actual findings by the doctors at Epic Pain and Orthopedics and the reported symptoms provided by my client in his history, regardless of whether Dr. Ozan agrees that those could be related to the wreck. The question is whether they are necessary treatment based upon the doctor's findings and the history, physical exam, and other diagnostic imaging, diagnostic tests that the doctors at Epic considered, including the imaging that were provided on his low back. So the question really here is whether Dr. Ozan is opining about causation, which is inappropriate, as opposed to whether the treatments provided by Epic Pain and Orthopedics was necessary. Some question whether Dr. Ozan is actually only attacking the Epic Pain and Orthopedics records, which it appears from the context of his affidavit, that's what he's doing. Although one of the affidavits, again, I said these both look like they're identical affidavits. One seems to attack Pain Clarity, although it never suggests that any of the treatment at Pain Clarity was unreasonable or unnecessary. So there's some confusion there. Maybe opposing counsel can weigh in and say whether they're actually only attacking the Epic records. That's what it seems to be, the import of the affidavit. But secondly, besides the causation issues, Dr. Ozan appears to not provide a reasonable notice of his basis as to why the Epic Pain treatment was not necessary in this situation, and particularly because of the finding of what Dr. Ozan says is there's no radiculopathy, therefore a lumbar epidural steroid injection would be unnecessary and of no benefit. He provides no explanation for why a epidural steroid injection cannot be used in other scenarios besides a finding of impingement or radiculopathy. So his statements are conclusory in that sense. So we would ask that the court strike Dr. Ozan's affidavit for those reasons.
Response?
Yes, Your Honor. Sorry, I'm trying to bounce between screens here.
Okay.
All right. Dr. Ozan's counter affidavit does only attack epic pain and the MRIs. And then with regard to, you know, the notice requirement of, you know, what he's saying, you know, I think the plaintiff attorney already kind of addressed that in the fact that Dr. Ozan basically said these are soft tissue injuries, and the necessity of an ESI and, you know, MRIs surrounding that treatment 4 months after the accident just aren't related to a car accident. And, you know, the necessity of the treatment is the core of what his counter affidavit is talking about. And I think plaintiff attorney, you know, kind of admitted that whether or not this was related to a car accident, the doctor can opine necessity. Well, exactly when can he opine necessity? If he doesn't feel that these soft tissue injuries, as alleged from the car accident, required additional treatment, that is exactly what we have our medical expert to review it for. Because I'm not a doctor, I can't discuss the necessity of it, but he can and say, look, you know, he didn't need epidural steroid injections as related to this car accident, and it's pretty cut and dry as to what he's talking about and why there's a lack of necessity. Plus, the plaintiff's medical records, you know, indicated that he had, you know, prior issues in these same areas, and you know, he'd been having similar complaints, although we got no records regarding that, and you know, so he may have had an underlying issue that, as of yet, we are unaware of. But it was kind of hinted in the medical records that Dr. Ozan reviewed, and thus his conclusion is that this treatment was not reasonably linked to a car accident.
I clearly think this affidavit really goes to causation, not to reasonableness and necessity. I'm going to go ahead and strike the affidavit. Anything else today, guys?
No.
No, Your Honor.
All right, guys, you be safe. You've been to mediation yet?
We have it scheduled, Judge. So, and there's a first party carrier also involved in the case. We probably will have another motion on one of their counter affidavits at some point, but we are scheduled for mediation. So,
okay, guys, have a great day, and we'll see you soon. And I have the order. I'll go ahead and sign it today.
thank you, Judge.
Thank you. All right. I think we next have the Signs versus Backer. Are both of y'all here?
Yes, Your Honor. Plaintiff is present.
Defense counsel is present, Your Honor. Good morning.
Morning. Okay, we have a motion to modify deadlines. When is the trial set on this case?
April. That's what I have.
Okay. All right. I'm kind of running behind, so I'm going to keep this a little bit short. Mr. Scott?
Yeah, I could probably do it in 30 seconds. This is the 8th hearing in this lawsuit involving a parking lot incident at a speed of a half a mile an hour. This is the first motion that I filed, Judge, asking for relief from you. At the last hearing, you allowed plaintiff counsel to take any expert depositions that they wanted. The discovery deadline expired in March. Beginning in 2019, we started requesting the films, coincidentally involving the exact same providers that were in the last hearing with the exact same facts, meaning that they had radiologists who said there was herniations and horrible injuries. And I wanted the films because I want them sent to a radiologist to determine if that was true. And I didn't get the films until after the discovery deadline expired. I did send the films to an expert, and sure enough, there were no herniations and no evidence of acute injury. So what I'd like you to do is dovetail the same ruling you had at the last hearing, and that is allow me to designate this radiologist. I don't intend to depose.
I wish because there's been so many hearings in this, that I allow the other side to designate additional experts or just to take depositions?
Take as many depositions as they wanted of experts. But we're not asking that, Judge. We're not asking for an expert deposition. We're just asking to allow me to designate this radiologist as an expert.
This is a new expert designation, which is very different than our last hearing, which only had to do with deposing an already designated expert of the plaintiff. And Your Honor, I'd like to, if you need me to respond in more detail, I'm happy to go through these deadlines and some of these assertions that Mr. Scott just put forward.
Go ahead.
Your Honor, we've had this scheduling order since June of 2019. Their opposing expert designation deadline was January 15th of last year, a year ago. They didn't even request specifically, and I attached the production where they asked for the films until after their designation deadline had passed. All that being said, Your Honor, they've had the films for over 8 months, and they not until November of last year did they actually request to do a new expert designation. And Your Honor, part of what our last hearing was is this is the second time that Mr. Scott has decided to designate an expert outside of their deadline. The reason why we had the last hearing is that there was a new designation of an officer. And so we asked to take the deposition of the officer and of our already designated expert. It makes no sense, and there's no justification for Mr. Scott being able to designate an entirely new radiologist 10 months after his expert designation deadline.
Mr. Scott?
And the basis for all those hearings, this young lawyer stated that it was my obligation to produce critical medical records and information to them. And this is exactly what happened. I, of course, wanted things like the films because they're very important, and they didn't give them to me until after the discovery deadline. I can't designate a radiologist and his opinions on films unless they give me the
Mr.
film.
Scott, when did you, she's saying that you didn't request those films until after the expert designation deadline is passed. Is that correct?
That's false. We had a request for disclosure in our very first answer. And then when we didn't get the films, I actually filed a formal request for documents that asked for the films. And the discovery deadline.
Well, a request for disclosure is not going to get you films usually. At least I've never seen it do that. So when did you send the specific request?
I believe the request for documents was in December.
It's part of our exhibits attached to our response exhibit A. February 5th is when he sent the request.
And when was the expert designation deadline?
January 15th for the defendant.
Okay. All right. I'm going to go ahead and deny the motion to extend the expert designation deadline. Did you submit an order, Ms. Reisinger?
I did this morning, Your Honor. I don't know if you can see it yet, but I can also email it to the court reporter and opposing counsel if that's more efficient.
Can you, go ahead and email that to my court coordinator, Rhonda, and Rhonda, go ahead and email that to me. Anything else today, guys?
Nope. Have a good week, Judge.
All right, you too. Good to see you guys. Bye-bye. All right, is everyone here for the motion for continuance? We've been kind of busy this morning.
Yes, Your Honor.
This is on the Pony Oil case.
Yes, Your Honor.
All right. And y'all are set for trial, what, tomorrow?
Say the 19th next week.
19th.
Oh, the 19th, okay. That was tomorrow. Okay, why don't you guys, I've read the motion for continuance. This is a non-jury case, is that right?
Yes, Judge.
I believe so.
So let me tell you my main concern, and I'll continue the case. Don't worry about that. This is my main concern is just, as you probably know, we have not had it. I've had one remote jury trial, but I haven't had any other jury trials. I'm concerned about, we've been trying as many non-jury cases as we can during this period where we haven't been able to try jury cases. And so I'm hesitant to move a non-jury case into a time period where we may be able to be trying jury cases. And so, your guess is as good as mine as when we'll be able to resume, regular jury trials. When I mean regular in-person jury trials. So that's my main concern is I don't mind moving it. I just don't want to have this interfere with my jury docket whenever that starts. And so,
And Your Honor, and Travis can confirm this, I think we've got this case settled.
oh, okay.
We're circulating final documents, Judge.
And we weren't able to get everything signed up before today, so we don't have an agreed final judgment to present to you today. But my expectation is that we'll have one presented to you by the end of the week.
Okay.
So, I think we're just trying to juggle multiple things, and I don't think we need a reset. I think just if you would grant the continuance, and hopefully we'll be putting this thing down by the end of the week.
Well, I'm going to reset it. If we're going to continue the case, I'm not going to just leave it without a trial setting. So,
or put us on the DWAP docket.
We'd be glad to do that.
That 30-day DWAP, and that should be plenty of time.
That sounds good to me. What about the opposing counsel?
Yeah, that sounds fine to me, Judge.
Okay, Rhonda, go ahead and put this case on a 30-day DWAP. It's DC 202144. Okay, she got it. All right, well, that was pretty easy. Glad you guys worked everything out, and we will see you soon. You guys be safe, okay?
Great. Thanks, Judge. Have a safe week.
Thank you. All right. Well, good morning, Miss Dean, Miss Favela. Welcome. It's your first day. Let me introduce you to the other interns while we have a short break. You guys want to introduce yourselves?
Yes, good morning. I'm Peyton.
Hi, I'm Samantha.
And you guys both go to SMU and are both 2Ls, correct?
Yes.
Yes.
And Morgan and Hernando, you want to introduce yourselves? And Josh?
Hi, I'm Morgan. I'm a recent grad from SMU, and I passed the bar, and I'm just applying for jobs right now. And Judge Hoffman was nice enough to let me intern for him.
Hernando?
Yes, so I'm Hernando Felix. I'm from Mexico. I'm a 3L at Texas Law. And nice to meet you guys. Also, I met Judge Hoffman through one of the outreach programs at Chelsea at UT. And then I messaged him, and he was nice enough to let me intern remotely because I'm not going to be in Dallas anytime soon. So nice to meet you guys.
Samantha, are you involved with HALSA